We are tracking for you today. Straight to the big story this evening. It's a huge setback for Edtech major Byju's, with the NCLT admitting the BCCI's insolvency plea against its parent Think and Learn. The company will now face insolvency proceedings and be run by an interim resolution professional named by the court for day-to-day operations. Ritu, you've been tracking that case. Tell us what this means for Byju's.
Well, you know, it is a bit ironic that Byju's got itself that sponsorship of the Indian cricket team's jersey to boost its brand, and now 5 years later, you have the company facing a downfall tied to that very move, with the NCLT now admitting BCCI's plea against Byju's parent, Think and Learn, for defaulting on 159 crores of payments and initiating insolvency and bankruptcy proceedings against the company. Now, the NCLT has named an interim resolution professional who will run the company until the official committee of creditors is formed. Do keep in mind, BCCI is an operational creditor, not financial, and under the IBC waterfall mechanism for the recovery of dues, creditors are ranked in a hierarchical structure, with secured financial creditors, for instance, getting the higher priority, followed by workmen dues, then operational creditors, and so on. Now, since there are foreign financial creditors in the case of Byju's with larger dues, the chances of BCCI as an operational creditor getting a decent recovery is lower under the IBC than, say, a settlement with the company outside of courts. Now, Byju's, in a statement to us, said they wish to reach an amicable settlement with the BCCI, and they're confident that they will be able to do so, and sources in the company also indicating that they may challenge the NCLT order in a higher court. So we'll have to see how all of this really plays out for the company. As for what's next, Byju's immediately comes under moratorium, so creditors cannot take any action to recover dues outside of the NCLT process. The committee of creditors will run the day-to-day operations through the IRP. Remember, IBC provides 330 days for the resolution, which can involve the sale of a company or, in the worst case, liquidation if all else fails. So as things stand, yes, the founders do run the risk of losing the company unless they're able to secure relief in a higher court or settle the matter outside of court altogether. But, you know, for more on this, I have some experts to answer more questions on what next for Byju's. Anup Rawat, who's partner at Shardul Amarchand Mangal Das, and Abhishek Rastogi, the founding partner at Rastogi Chambers. And also with me, my colleague Shruti. Anup, hi, welcome to CNBC TV18. This is Ritu. Simple terms, Byju's now under IBC. What does it mean for all of the stakeholders? Briefly, it immediately goes under moratorium. So, you know, all of the parallel cases that are against the company from the investors and the creditors, what happens to them?
Yeah, thanks, Ritu. I mean, you rightly said that. You see, the insolvency code is meant to provide a calm period. What it means is that once the insolvency proceedings are initiated against a corporate debtor, and in this case Byju's, it has to go through a period where nobody can continue to litigate to recover their claims, and there is a process where the claims will be invited by the IRP, and all the claims will be submitted, and they will be subject to the resolution under the court. So it is good and bad in the same way, because good because, you know, now the company can go through a resolution process period without getting bothered by various other litigations. Bad because the current management will lose its control. They will be called the suspended directors, unless, of course, as you said, they challenge and reach some kind of a settlement with the creditor.
All right. Thank you for that, Anup. This is Shruti quickly stepping in. Abhishek, I want to ask my next question to you. What are the options for Byju's? They've said that they are in discussions with the BCCI to settle the matter. In your experience, what happens in such cases?
I think, keeping in mind the reputation of both BCCI and Byju's, they would opt for a settlement here. Keeping in mind also the valuation of the company and the amount involved, I don't see this is a big amount, and the disputed amount, even if we talk about the pre-existing dispute, would not be to a very large value. So I think in most of these cases we have seen, and we expect that, you know, there will be a settlement between BCCI and Byju's. So, you know, we know for a fact that the resolution plan, it will take some time. And before that happens, the initiation happens, there is still time under 12A to do this. So that is a clear option, a viable option, which we feel, you know, should be opted by both the parties. I think the second related aspect, or the second option, is to examine the pre-existing disputes, see how, I mean, it appears that, BCCI must have done the ground reality check and would have got all the grounds in place. But Byju's has an option to appeal this order and go to NCLT and CLAT, and it will have to then demonstrate the nature of the pre-existing disputes, that when on the date of this demand notice, when all of this was initiated, what were the trigger points prior to that in terms of possibly things like quality of service, or the agreement or the contractual aspects, because of which there is a dispute with respect to this figure and things like that. That's the option which would be more feasible only when on the contractual terms and based on facts, Byju's is on a strong position, which to me appears as of now, because NCLT has passed this order. It appears that BCCI would have done the homework quite well on the ground level and would have covered all of these aspects from the pre-existing disputes perspective.
Well, Anup, let me take forward that point Abhishek was making. I'm sure BCCI has done the homework, and I know the amount, probably 158 crores, doesn't seem too large. But, Anup, given the fact that BCCI is an operational creditor, now, under the waterfall mechanism, what are the chances they may even make any recovery here? Wouldn't it be in their interest to settle outside? Or, what do you expect the next course of action should be?
No, Ritu, see, before insolvency court, the recourse available to the operational creditors was very limited. They had to go to the civil courts. Now, what insolvency court does is that if the company is really in a position to pay, then an insolvency petition does trigger a very quick settlement. And what is worrisome is that that has not happened so far. And NCLT, Honorable NCLT, has admitted the petition. What it means is that the insolvency position of the companies, is in question. We also know that there are several other petitions pending in the NCLT for the initiation of the insolvency. So the question, I think, is not about what happens to BCCI. I think it's a larger question of solvency of the company. And even if you settle this one, I mean, are we kicking the can down the road? So somewhere it has to be seen that what is that. What is the position of the company, whether it is in a position to, sort of come back to a situation where they can continuously honor their debt obligations.
Sure.
It seems to be a bit doubtful at the moment, yeah.
Anup, picking up from what you just said, tell us how big of a risk is Byju Ravindran of losing his company. Byju's lenders group in the US has also taken the company to the US bankruptcy court, and the court has frozen the $533 million loan proceeds. What happens to those cases as well?
See, it's a very complicated question, and it's not only the question of Indian jurisdiction. I mean, Byju's operations run in several countries. So there are complicated questions of cross-border insolvency issues. So, it's very difficult to at the moment say that, what will happen in US. Clearly, we are seeing that there are certain creditors who have initiated the proceedings here as well. So, and at times, it's a domino effect at times. So unless, we have a very quick revival package, which is quickly agreed amongst all the lenders, the company and Mr. Byju will be, in difficulty of losing the management and the company facing the insolvency issue. But, it's not, given the nature of the business that Byju's run, it's also true that, insolvency may not be the only solution here, because what happens also in insolvency, you quickly lose your business, your working capital dries up. So therefore, I think in a company like Byju's, I think it would also be prudent for lenders to see that there could be a quick settlement or a revival package agreed to end this situation and put the company back to the revival path.
Well, Anup, as you're saying, it is a complicated case, no doubt, and it surely will set a precedence, especially when it comes to startups undergoing IBC, and have obviously repercussions for the funding for edtechs in India as well. But we've run out of time. Abhishek and Anup, both of you, thank you very much for your time here on CNBC-TV18 and helping us understand what this means for Byju's.
Thank you. Thank you, Ritu.
All right, with that, it's time for us to head into a short break. But coming up, Amazon Web Services and Tamil Nadu's primary startup incubator, IT&T Hub, join hands to build an accelerator for the state's AI-first startups. What does this partnership entail? We'll tell you on the other side. Stay tuned.